Picture this. You wake up one morning and, completely out of nowhere, you find out a false FIR, a first information report, has been lodged against you by a vindictive neighbor. Or maybe a simple business dispute you had has suddenly been aggressively twisted into a criminal complaint. Or, in some cases, it could even be straight-up political victimization. Honestly, few moments in a person's life are as genuinely terrifying as the fear of an unjust arrest. Any of these scenarios can place an innocent citizen entirely at the mercy of the police. So what happens when you find yourself in this exact terrifying situation? Well, Pakistani law actually responds to this specific danger with a profoundly powerful legal shield. It's a preemptive remedy designed to protect your liberty before the handcuffs ever come out.
Welcome to this explainer. I am so thrilled to guide you through today's topic. We're going to be demystifying the high-stakes, heavily scrutinized process of securing anticipatory bail, or as it's more precisely called in Pakistan, bail before arrest. We're going to unpack the statutes, decode the specific judicial tests, and walk you step by step through the filing procedure you absolutely need to know to secure this vital constitutional safeguard.
Okay, let's dive right into this. Here's our roadmap for today. Number 1, the shield against unjust arrest. Number 2, the statutory framework. Number 3, pre-arrest versus post-arrest bail. Number 4, passing the twin test. Number 5, step-by-step filing procedure. And finally, number 6, why petitions get rejected.
Let's start with Section 1, the shield against unjust arrest.
To kick things off, we really need to understand that this is not just some casual favor from a judge. It's an extraordinary remedy, and it's granted very sparingly. So what is it exactly? By definition, bail before arrest is a protective court order. It basically directs that if the police try to arrest a named person, that person will be released on bail rather than being taken into custody. But here is what's absolutely crucial to understand. This order does not erase the criminal case. It doesn't stop the police investigation at all. It simply shields the applicant's physical liberty while that investigation proceeds.
Moving on to Section 2, the statutory framework explained.
Now, here's an incredibly fascinating quirk of Pakistani law. Unlike India, our criminal code doesn't actually contain a section specifically titled anticipatory bail. So where does it come from? The bedrock of this power is Section 498. The superior courts have creatively read the power to grant bail before arrest into this specific provision, and their reasoning is actually pretty elegant. If a court has the power to grant bail after an arrest, well, that same court surely has the power to prevent an unjust arrest from happening in the first place.
Of course, Section 498 doesn't just operate in a vacuum. It sits alongside a few other crucial legal provisions. You've got Section 496, which makes bail a matter of right for minor bailable offenses. Then there's Section 497, which governs post-arrest bail for more serious non-bailable offenses. And this serves as a major reference point for judges. And then we have Section 561A. This one covers the High Court's inherent powers, and it's particularly vital because it's frequently invoked for things like transit bail or protective bail. You'd use this when you're facing imminent arrest in another city or province, and you need safe travel to actually reach the court that holds jurisdiction over your case.
Which brings us to Section 3, pre-arrest versus post-arrest bail.
Now, you might be wondering, why go through all this trouble before the arrest? And this brilliantly illustrates the divide between the two. Post-arrest bail is sought when you are literally already in a jail cell and the court actually has some collected evidence to examine. Pre-arrest bail, on the other hand, is based on the mere apprehension of an imminent arrest. Because the case is so undeveloped at this stage, courts have ruled that pre-arrest bail is significantly harder to obtain. Plus, you can't just hide out and apply from the shadows. You must genuinely be at risk of arrest and fully prepared to surrender to the court.
Let's look at Section 4, passing the twin test.
Because this pre-arrest remedy is so extraordinary, the courts have designed a rigorous two-part hurdle that every single applicant must clear. This is known as the twin test. Lim 1 deals with the merits of the case. Basically, you must show reasonable grounds for believing you are not guilty and that the case needs further inquiry. But here's the catch. Proving innocence is not enough. You must also satisfy Lim 2, which is mala fide. You literally have to prove malicious intent. You need to show that the arrest is being sought out of some ulterior motive, like a political rivalry, personal enmity, or police misuse, rather than to actually further justice.
And this twin test wasn't just created overnight. It was forged over decades of landmark Supreme Court rulings. Back in 1953, Qc Muhammad's case established that the High Court has concurrent power to grant bail, meaning it doesn't just have to wait around for the lower courts. In 1966, Sadiq Ali's case cemented the rule that you must face a real apprehension of arrest. You can't just claim it in the abstract. And then we have the 2009 Rana Muhammad Arshad case. This one is huge. It's essentially the modern charter of pre-arrest bail law in Pakistan. It laid down the definitive framework that this is an extraordinary relief meant specifically to protect innocent citizens from victimization. Pretty much every high court order on the subject today starts by citing this exact 2009 case.
Okay, let's move to Section 5, Step-by-Step Filing Procedure.
So we've covered the theory. Now let's look at the real-world playbook. It's a very meticulous, chronological process. Step 1, your counsel conducts a case assessment. They review the FIR and gather evidence of enmity to build that absolutely crucial mala fide argument we just talked about. Step 2, they draft a petition and file it urgently in the Sessions Court or the High Court if applicable. Then at the first hearing, Step 3, the court usually hears only the applicant and might grant ad interim bail. This is a temporary shield usually lasting for about 10 to 14 days, stopping the police from arresting you immediately. Step 4, official notice is issued to the prosecution. Then we get to Step 5, which is the real climax, the confirmation hearing. This is where both sides argue the merits and the mala fide. The judge will either confirm your bail, protecting you all the way until the trial, or recall the temporary order, exposing you to immediate arrest. Finally, Step 6 is compliance. You have to provide a personal bond, not tamper with evidence, and join the investigation. Or, if you lost at Step 5, Step 6 is where you urgently appeal to a higher court.
Which brings us to our final section, number 6, why petitions get rejected.
All right, we have to pivot to the harsh reality here. Courts deny these petitions frequently, and honestly, the margin for error is essentially zero. Let's look at the most fatal mistakes. First, failing to provide credible proof of mala fide. Like we said, if you can't prove the malicious intent, you fail. Second, if there are direct, specific, and corroborated allegations against you backed by forensic evidence, the court will very likely just let the arrest proceed. Third, and this is a massive red flag, unexplained abscondence. If you have been a fugitive actively evading arrest instead of showing a genuine willingness to surrender, you automatically forfeit this protection. Remember, this tool is for the threatened, not the evasive. Fourth, concealing a prior dismissed bail petition. According to Zubair's case, hiding a previous rejection is viewed as deceiving the court, and it is instantly fatal to your new application. And lastly, any subsequent tampering with evidence, that will get your bail canceled immediately. So, for any of the legal practitioners watching, or really anyone preparing their case, here's a golden practical tip derived directly from the case law. Plead mala fide with extreme specificity. Vague, generic claims of false implication almost never succeed in these hearings. You must explicitly document the enmity, particularize the timeline, show the prior civil litigation, or the specific procedural delay in registering the FIR that actually proves the police process is being misused against you. To bring this whole shebang together, we have to anchor this entire procedure back to its constitutional roots. Because the whole reason this complex, demanding process exists is found right in Articles 9 and 10A of the Constitution of Pakistan. These articles guarantee the security of person and the right to a fair trial. They establish the foundational philosophy of criminal justice, which is liberty is the rule and detention the exception. Bail before arrest exists for one precise reason: to prevent the coercive machinery of the state from being weaponized into an instrument of personal vendetta. So, we'll end with this thought. Understanding the twin test of merit and mala fide, choosing the correct legal forum, and presenting an honest, well-documented petition isn't just about winning a court case. It's about actively securing a vital constitutional safeguard for personal liberty. If liberty is the rule, are you prepared to defend yours with the right legal shield? Thank you so much for joining me on this explainer. I really hope this helped demystify a truly critical aspect of the legal system for you.